Thank you for joining us. We are going to start now. Thank you for being here in this workshop from the Forest Legal Talk. We hope this is going to be really helpful for all of you that are interested in having a visa to the United States. We have two experts here, so I know it's going to be a great workshop. So please do not hesitate to ask any question or to raise your hand if you want to ask them something. So thank you again and welcome. Hope you like it. And we are going to see each other in many legal talks.
Well, thank you, everyone. It's a pleasure to be here and be a part of this project on behalf of the Forest Puebla and to participate with Rebecca Lenetsky, who's an expert in the U.S. immigration area and who will explain to us every important aspect we must consider if we are looking forward to relocate to the United States. We have prepared several scenarios which we think are the most relevant to our clients. Please, if you have any doubts, feel free to ask them through the chat, and we will review them and choose the most relevant. I'll let Rebecca introduce herself and start the workshop.
Hi, everyone. So my name is Rebecca Lenetsky. I'm an immigration lawyer based in New York City, but I work with clients across the United States and, in fact, across the world. My area of specialty is immigration law. I help people move from across the world to the United States in all different types of categories. For the past 10 years, I've been working primarily with people in employment-based immigration, as well as some family-based immigration, investors, entrepreneurs, artists, founders, scientists, all different types of areas of expertise and specialization to help them relocate to the US and pursue whatever endeavor they see fit. So with that, we entitled today's presentation, US Immigration and Relocation for Mexicans in 2020 and onwards. And that's because in 2020, obviously there are special considerations given that we are in a time of extreme change in a lot of respects, including US immigration law, including many travel restrictions into the United States as well as out of the United States. But with that being said, we need to look towards the future as well. Some of these changes may endure, many of them will not. So we'll be focusing on a mix of how things look in the present, as well as how things may or may not be looking going forward, and sort of a general overview of immigration options.
So, Rebecca, as we all know, the pandemic has significantly affected travel between the US and Mexico, especially immigration processes. Can you give a quick update on the most significant developments and restrictions currently in place?
Yes, so first we'll talk about some travel restrictions related to COVID-19. So this is specifically to do with moving in and out of the United States, not to do with visa categories or visa processing or things like that. So currently the land border crossing from Mexico is restricted to essential travel, so not tourism. However, you can travel by air. This is going from Mexico into the United States. So going from the US into Mexico may be an entirely other matter. The same is true with the Canadian border. Travel into Canada is highly restricted. However, travel from Canada, for example, to the United States is open, at least by air. So if you have a business-related reason, a commercial reason that you have to travel over a land border, so trade, supply chain, things like that, the land borders are still open. That's considered essential travel. But if you are a tourist, you won't be able to enter over a land port of entry. There's also travel restrictions I just wanted to mention from other places in the world. So entering from the Schengen zone in Europe, the UK, Ireland, China, Iran, Brazil, and this applies to all foreign nationals, meaning people who do not have a US passport or are not green card holders, who are either traveling from these areas or transiting through these areas. So even if you have a stopover in a European country that's in the Schengen zone, which is most of Western Europe, you would have to go to a third country, stay for 14 days before you're able to come to the US. And the only exceptions, I said, are US citizens, green card holders, or immediate family members, so spouses, children, sometimes parents, and as well as essential or national interest workers. So you can get an exemption, but only if you apply to either Customs and Border Protection, so CBP Customs, or to a embassy to have yourself recognized as being an essential worker or a worker in the national interest, meaning you're working on something to do with supply chain, with healthcare. Obviously, if you have anything to do with COVID research or treatment, they are more likely to let you in. I have gotten exemptions for someone working as a COVID-19 researcher who's coming from a European country who is then able to get a visa to come, but the exceptions are fairly limited. The consulates are sometimes open, sometimes closed. All of the consulates across the world closed in the middle of March. They've been slowly reopening. In Mexico, there is limited availability of appointments for students, for TNs, for some tourist visas, but the appointments are fairly limited. They're very, there's a lot of restrictions because of just safety measures, and generally speaking, it's unpredictable whether the consulates will necessarily at all points stay open. There was obviously a lot of backlog, and obviously they want to make students able to allow students to enter the United States. They can't indefinitely close consulates, but there are places around the world where the consulates still have not reopened for almost anything. So there's really a difference from consulate to consulate. There are emergency appointments, but again, it varies from country to country, from city to city. There's some consulates in Mexico that are still not really open. I think in Juarez, they're still very much closed. So it really depends on the consulate. A
So,
very hot
Rebecca,
topic.
I'll ask you,
Yes, go ahead.
I'll ask you a really important question and something that our clients have asked us before. Right now, with the whole situation with consulates due to COVID-19, if you have to send personnel to the United States and they don't have a visa, does a business emergency qualify to the criteria necessary to ask for an urgent visa appointment at the consulate?
I would say it depends on how you define business emergency, and it depends on how well you can sell it to the consulate. So, for example, if you have a visa and you're subject to a different travel restriction, so you would have to apply to Customs and Border Protection, not through a consulate. What we've seen over the past month is that Customs and Border Protection is fairly lenient. They're pretty open to different arguments about what essential travel is. The consulates, I'd say, it varies from consulate to consulate, and it would depend on what the business necessity is, and it depends on what kind of emergency we're talking about. So if we're talking about, or it depends on the availability of the appointment to begin with. So if there's no appointment, if the consulate is really closed, then I think you're unlikely to get an emergency appointment. It depends on what the situation is in that area at that time. If you're talking about the consulate that is scheduling appointments and there's some other restrictions. So for example, in the presidential proclamations we'll talk about now, they are more open to business emergencies, but you have to take an angle towards it that matches what they're looking for. So you have to try to fit yourself into one of the exception kind of categories. So things like supply chain, things like protecting investments in the United States, they're fairly open to, especially obviously anything with healthcare or medicine or anything like that. So, or medical research. So, or medical supplies. So it really, I would say depends on the consulate, and it depends on the reason for the emergency and how well you can fit it into one of the exceptions they're looking for. I know it's not a very satisfying answer sometimes, but it's certainly worth a try. It just, there's just no guarantee, but there's never a reason not to try, I think is the bottom line. So I'm going to turn to the presidential proclamations, which got a lot of coverage in the news. There were tweets before the proclamations came out, and then the proclamations came out, and there was a lot of lack of clarity about what they actually meant. And so since they came out, we have progressively gotten more and more clarification from the Department of State, from other immigration agencies about what these actually mean. So I'm going to give an overview of what we know that they mean in the present, in now October 2020. What do we know that these mean? So there was initially a proclamation in April 2020 limiting the issuance of immigrant visas. So if you were sponsored by a employer for a green card, they said we're pausing issuance of these visas. But that really only meant through the consulates. Everyone in the United States was still able to apply for the green card. And the consulates were still processing, in theory, immigrant visas for spouses and children of US citizens, for investors, for healthcare professionals, for all different other immigrant visas. The truth was that in April 2020, none of the consulates were open. So this affected almost no one. In June 2020, there was a subsequent presidential proclamation. It restricted the issuance of new visa stamps through the US consulates for certain visa categories. So certain temporary work visas were now not going to be issued new visa stamps. This is H-1B, L-1, certain J-1s, and the dependent of kids, it wasn't clear whether they would qualify. So if your spouse had an L-1 and you wanted to join them in the United States, it wasn't clear whether you would be able to get a visa or not. They've since clarified that dependents, so spouse and kids, are not included in this. So if your spouse has a visa, is in the United States, or had the visa and is going to the United States, you can still get a visa. It doesn't affect those with valid visas or those in the US in legal status. It extended the proclamation restricting the issuance of immigrant visas for employment-based visas. It said it expires in December 31st, 2020. And it said there's a variety of exceptions. So for national interest, US supply chain, etc. We have since learned that it won't apply for renewals. And we'll talk about this more later when we talk about the L1. So if you had a visa or in the United States, you got your renewal, you need to go back to a consulate. It doesn't apply to you. You can get a new visa at a consulate. They gave a whole list of exceptions for L1s, for H-1Bs, for different types of, different categories, what different exceptions are. We'll go over some of them a little bit later when we talk about the L1. And really at the time as well, even in June, the consulates were only very slowly opening. So even though there were no other categories that were covered by this, issuance was de facto on hold. No issuance of visas was happening. No one was getting a visa. So now that has changed. Now the consulates have been reopening. Sometimes they've been closing again, depending on the country. So again, these presidential proclamations sometimes have a big impact, sometimes have very little. Like it really, it seemed to be very restrictive at first. Now they have expanded it significantly. I would say that the category most affected is the H-1B, which we won't be talking about so much today, but we can talk, if there are questions at the end. I'd say that's the category that is most affected. I'll only just touch briefly on what's going on in terms of USCIS processing. So that's the Citizenship and Immigration Services in the United States, the agency that processes petitions, that processes green cards when you're applying in the United States. Right now, there are not really significant changes in play. I would say, they've resumed premium processing, which is the expedited processing. That made a big difference when it was suspended for a few months. Right now, there are no furloughs of employees. So while we're seeing some slowdown of processing in some areas, we're actually seeing it sped up in other areas because they're getting fewer applications. Green card interviews at local offices have slowed down because they're only working at a much smaller percentage of the workforce. They're only taking a few interviews per day. But generally speaking, we're not seeing really major slowdowns right now, and this is not affected at all by the presidential proclamations. So, the fees have gone up, the fees are going up. We're seeing a lot of court-related changes going back and forth, but generally speaking, the processing in the United States has not been so significantly affected in terms of formal rules connected to COVID.
So, Rebecca, what are some of the basic things to know about immigration options for relocating to the US?
So I want to just cover a few concepts before we really get into the substantive material. So there's two types of status options. There's immigrant status and there's non-immigrant status. And this is a big distinction that people have to keep in mind when they're talking about relocating to the US, because a lot of the time I'll speak to someone who says, I want to get a green card. I want to relocate. I want to get a green card. I'll say that's great, but you need to know what that looks like. You may qualify for a green card. You may be able to invest money towards getting a green card. You may have someone who wants to sponsor you for a green card, but the process of getting that may be significantly longer than getting a short-term temporary non-immigrant visa, meaning it's restricted. Doesn't give you long-term permanent status, and then either subsequently or at the same time applying for an immigrant status, for a green card, because the non-immigrant process usually can be expedited. It usually doesn't have the long processing times that green card has. Overall, it can get you to the US much faster. So this is a conversation I often have to talk about what are the timelines. Everyone or many people want to have permanent resident status. Sometimes there are reasons not to want permanent resident status. Sometimes you want the flexibility of being able to be in or and out of the United States more flexibly than a green card will give you. There may be tax reasons you don't want a green card, but this is a really important concept in immigration law. There's no one-size-fits-all pathway to either immigrant status or non-immigrant visas. So there's no general work visa you can get. So you can't just apply for a work visa. You have to fit into a specific category. Same applies for immigrant status. So these categories are primarily separated into family-based green cards, employment-based green cards or non-immigrant visas, so temporary work visas, of which there are different categories, investment non-immigrant visas or green cards, so that's the E2 investment visa or the EB5 investment green card, and then humanitarian categories, so that's asylum, there's a green card for victims of crime, so that's a totally other category. So today we're going to focus mainly on the employment and investment options. We can also take questions at the end about, I guess, family-based immigration or humanitarian types of immigration, but generally today the presentation will focus on employment-based and investment.
So, Rebecca, let's pretend I am a Mexican citizen interested in starting or investing in a business in the United States. What are my immediate and long-term residency options in the US?
Okay, so the two quickest and most effective options for entrepreneurs or investors are the E2 treaty investor visa or the L1 intercompany transfer visa. So these two will get you to the United States as long as you qualify for in a relatively short period of time. They're not permanent residency. They're not necessarily long-term planning, though each of them are for several years. We'll go over that. But for longer term planning, you could apply for the EB5 immigrant investor green card, which takes much longer to process, but is obviously a long-term plan if you want to really remain in the United States. So the L1 intercompany transferee visa is for when there's an existing foreign business. It must have been operating for at least 1 year. And you either start a new business in the United States or there is an existing business in the United States with a corporate relationship that qualifies for the L1. So there needs to be at least 51% common ownership between the foreign company and the US company. So that means the foreign company can be the parent company, the foreign company can be a subsidiary of the US company, there can be a branch, it can be affiliate, meaning there's 51% shared ownership of both. So 51% of the foreign company has a certain owner or certain owners, and then 51% of the US company has a certain owner or certain owners. So that needs to be established before you apply. The investor needs to have been employed by the foreign employer for at least 1 year out of the past 3 years. So if you are an investor and you want to move yourself to the United States, you've been running your company in Mexico or somewhere else, and you either have an existing entity in the United States, or you want to start a new entity, or maybe you're even acquiring an entity that's already existing in the US, then you have to have been ideally on the payroll of the foreign company for a year, but if not able to show, then at least able to show that you've been employed. So you've been taking dividends, you've been, receiving some sort of compensation, or you've been working for it in some way. You need to have been working in an executive, managerial, or specialized knowledge role. So executive, managerial, obviously are fairly self-explanatory. You've been running the company, you've been managing the company. Specialized knowledge role is one we sometimes use when the company is not so big and maybe you can't really show that you've been managing a lot of people. Immigration services really likes to see that you have a lot of people that you've been managing a complex organizational structure. So if it's a smaller company, we may describe you as a specialized knowledge worker, meaning you have really deep knowledge of your company and what they do, and that can't easily be replaced by someone else. So they need you, the company needs you to move to the US to run the affiliate company. The companies don't actually need to have that much to do with each other in terms of operations. The critical connection is the corporate connection. So there needs to be 51% common ownership. Critically, the foreign business also has to continue to operate. So if you want to move to the US, shut down foreign operations, that's not going to work for the L1. You need to have a foreign company that continues to do business. And not just stay there, not doing business, just open. It needs to be really continuing to do business. They will ask to see the tax returns. Down the road, you'll need to show that the company has actually been operating. The other option is the E2 Treaty Investor Visa. For this option, the US company needs to be 50% owned by a Mexican national or entity. If you are the Mexican investor transferring yourself, or not transferring yourself, rather, relocating to the US, you start a company in the US or you acquire a company in the US, you need to have at least 50% shared nationality. So it needs to be at least 50% Mexican owned. If you hold another passport, you could be working for a company with 50% ownership of that nationality. So for example, if you had a Spanish passport, a Brazilian passport, etc., you could work for a company owned by 50% of that nationality, but that's the critical point. So if you start a company, you need to own 50% of it. You can buy an existing company, but again, you need to buy at least 50% of it. You need to show that you have put substantial investment into the US. So substantial is not actually defined specifically in the law. Substantial means whatever the concept wants it to mean. So it's usually relative to the startup cost of the business, or if you're buying an existing company, then it's relative to the fair market value of the company at the time that you purchase it. So, I mean, there are certain guidelines. There's things, there's amounts that we know work better at certain concepts than others, or that work just generally. But we are talking about several tens of thousands of dollars at a minimum to invest in a new entity. You need to show that these funds were put at risk. So you need to actually spend the funds. You can't just put them in an account, an escrow account. You need to actually show that you have put these funds somewhere that if you do not get the visa, you will still lose it. And the company can't be marginal, which means that it's not just for you. it's not just for you and your family. You need to be planning to hire other employees or have already hired other employees. And you need to be coming finally to manage or oversee the company. So that, or again, work in a specialized knowledge role, but generally if you're the investor, the intention is that you're coming to manage or oversee the company. It's not a passive investment. So this is also something that we get asked a lot. Can I purchase a property? Can I buy a home? Can I buy an office building? And the truth is, even though an office building is doing business in the sense that people are working in the office, if it's not your company that you're running that's working in that business, that's considered a passive real estate investment. It's not really that you are creating jobs in the US. There's also an option for treaty traders where you're trading goods from the country of nationality, the treaty country, so in this case Mexico, to the US. We use this less often because you, number one, need to have been having had international trade over the last year, so it doesn't work for new businesses. And showing the amount of trade is often a lot harder than showing investment. And usually if you have an E1 company, you also have invested money in the United States, and it's often easier to just do the E2. But this is sometimes an option if you have a lot of trade between the two countries and you don't want to spend more money on a new business in the US.
So what are the advantages or disadvantages of the L1 visa?
I'm glad you asked, Jesse. So the pros of the L1 are that there's no specific financial investment requirement. You do need to obviously start up the company. You need to have office space. You need to show that you're putting a payroll in place, that you have committed to the company if it's a new company. But if it's an existing company, you really don't need to show anything about any amount that was transferred. You don't need to show where the money came from. And there's no minimum amount. USCIS is never going to say, well, we just feel like this is not enough money that you've invested. So really the threshold for the financial investment is a lot lower. It's processed through USCIS, not through the consulate, which I would say is very often an advantage because it gives us, the lawyers, a lot more opportunity to advocate on behalf of the client, whereas at the consulate, the processing times are a lot longer. You can't expedite it. You're subject to things like COVID, shutting down the consulates. There have been other reasons the consulates have shut down before in the past that have been not as dramatic, but really it does give us a lot more control than the E2. The ownership must be qualifying, so it needs to be 51% common ownership, but it doesn't necessarily need to be Mexican. So there can be a qualifying relationship between the two companies, parent, subsidiary, affiliates, but it can be by any international company. It doesn't matter who owns the company. So even if you're working in Mexico, but the company you're working for is not owned by, or you own a percent, let's say you're the investor, you own a percentage of the company, and you own a percentage of the company in the US, but you don't own 50% like you would need for the E2, or it's not 50% owned by other Mexican nationals, it's owned by nationals of other countries, for example, you would still be able to transfer. And it's also great because you can acquire an existing business as long as the qualifying relationship is there. So if your company in Mexico, for example, acquires a company in the United States, that gives you a lot more ability to show that it's an existing business, it's been doing business, and that's obviously more convincing to USCIS at times than having to start a new business in the US and and then convince them that this will actually grow and get you a temporary visa that you will have to extend later. The cons are that obviously you need an existing business in the foreign country, in Mexico or another foreign country, and you need to have been employed by the company or working for the company, and it needs to have been operating. The foreign company also has to continue, so you cannot just give up your foreign business, you can't give up the foreign operations. Even reducing it may at times make a renewal in the future problematic. So that's something you have to think about carefully before you apply for the L1. A qualifying corporate relationship may not be possible. You may not be able to show the 51% ownership. For new US companies, as I said, this would be the advantage of acquiring an existing US business. If you start a new company, you only get initial 1-year approval and then have to renew it after the 1 year. And you have to show that you've more or less met your hiring targets. So the employees you said you were going to hire, you've hired them. For a smaller company, this may be hard to show that it's complex enough to qualify for the L1. If you only have a few employees, they may not consider you really an executive, and you have a maximum stay of 7 years.
So what would be the advantages or disadvantages of the E2 visa?
Different but overlapping with the L1, I would say. So the pros are that there's no specific company or work experience required. You don't have to have any prior experience in Mexico with any particular company or anywhere else in the world. Obviously, if you have a track record as an entrepreneur, a track record as an investor, that will help you qualify for the E2, but you don't necessarily need to show any connection with a specific company. And new companies and acquisition of existing businesses will both qualify. Whether it's a new business or an existing business, as I said, will change how much you need to show you've invested. And there's flexible ownership requirements more than, for example, the L1. And there's no maximum time period. You can stay on the E2 for as long as you want. I have had clients who've been on E2s for 20 years. They didn't want to get a green card. They stayed on the E2. The cons are that obviously you have to make a substantial investment and you have to spend it. And you have this ambiguity of, will this be enough to qualify? So this is evaluated on a case-by-case basis. There are some consulates that are very hard on E2s. There are some consular officers that are very hard on E2s. So you're going into this not knowing for sure if the money you spend will necessarily lead to a work visa. You need to show the source of funds. This also depends on the country. Some countries, the consulates will be more strict about wanting to see where the money you invested came from. They'll want to show they'll want to see it's from legal channels. I would say that Mexico can sometimes be a little bit hard on this. Sometimes they really do want to show, they really do want to see, where did you get the money that you're bringing to the United States? Was it through legal sources? This is adjudicated through the consulate, which I don't think any immigration lawyer would say is preferable if you can avoid it, because then you're at the mercy of a consular officer. Again, it depends on the amount of experience you have and the strength of your case. This is not to say that you cannot get an E2 easily approved at consulates, but this can take a lot longer, and it leaves you in a situation where you have to depend on what the consulate is doing at that time. It can also make a transition to a green card difficult if the company is majority owned by an investor. Generally, you can't sponsor yourself for a green card. So transitioning from E2, if you are the primary investor, to a green card, it can be tricky and usually not possible with your own company.
So what is the process for an investor who wants a green card?
So the process for the EB-5, the investment amount is clearly defined in the law. You're not dealing with these vague definitions of substantial. So you need to make an investment of either 900,000 or 1.8 million. It depends on where you are investing the money. So there's some areas that are designated as areas where there's high unemployment relative to the United States or relative to the general numbers that they're looking for in the United States, and you can invest a lower amount. The amounts were raised last fall, and the definition of the location was also changed last fall. So this has become a lot more difficult to meet and a lot more unpredictable, because it used to be determined by the state and now it's determined by the federal government. So it is usually many investment opportunities for the EB-5 are actually only taking the 1.8 million now. So that is making it significantly into a significantly higher financial burden to meet. The funds must be invested and they must be at risk, similar to the E2. You need to actually transfer them. If you're transferring them into an existing regional center, so a project that has been set up specifically for the EB5, these, we're talking about like large tourism projects, large residential projects, basically big building expenditures that get a pool of investors through the EB5. Usually they just require you to transfer to escrow, but you've already entered into a contract where you are obligated to spend the money. If it's your own business that you're starting, then you do need to show, like the E2, that the funds were invested, the funds were at risk. So you actually transfer them to the United States and you've spent the funds. You can't get them back. They're not just sitting in an escrow account. The business must create 10 full-time jobs at the end of 2 years after you have gotten the approval. So it doesn't need to be at the time that you're applying for it, but 2 years after you get the approval, you have to then reapply and show that you created these 10 full-time jobs. The ability to trace the legal source of funds is extremely, extremely, extremely important in the EB5. We're talking about a lot of money, and the US government is really trying to avoid people using this as a source of money laundering into the United States. So you need to very carefully trace where the funds came from, how you earned that money, where the necessary taxes placed on them. If there's any break in the movement of the money from the foreign country to the United States, that's going to raise big questions. So if there's difficulty transferring funds out of a country, that's going to be a big issue. You cannot, just move the cash to somewhere else, put it in a bank account, and then move it to the United States. So this is going to be really important to document. And if your money is if the funds are from a lot of different sources, this can also be difficult to document, because then you need to show where all of these different sources originated. So if you're talking about sale of real estate, sale of stocks, employment income, and all of it gathered together, it can sometimes be tricky to show this. There's also a lengthy processing time. So the processing time for the temporary 2-year green card is over 2 years. And then even once you get that, you need to apply for the permanent card 2 years after approval. So the EB5 is a great option if you have the money, you have a business you want to invest in, someone else's business, your business, a regional center, and you want the long-term option. But if you're talking about short-term relocation, then we're really talking about ideally doing an E2 first, and maybe you can even use that same business to do an EB5 if it warrants this amount of investment. But the EB5 is not a short-term option. So if you want to relocate in 6 months from now, it's not through the EB5.
So what should investors be aware of with EB5 investments?
So my word of caution about the EB5 is to be extremely careful about what project you are investing in. I don't want to be negative about the EB5. I've gotten a lot of EB5 green cards for people successfully with all different types of projects, but generally speaking, if it sounds too good to be true, it probably is. So if you're being offered a really high rate of return, they promise, we'll give you 10% a year, we'll buy you out after you get the green card, don't worry about it, this can't fail. You should really think about whether this is a promise they can make, because if you're not running this company, which ideally you should be for the EB5, or if you're not running the company, it should be in a regional center that's already been certified. You need to think very carefully about whether the project that you're being sold is going to lead to an outcome you want, because in the end, if the EB5 fails, you can lose the money and not get a green card. So sometimes you will want to prioritize a high rate of return, but that might jeopardize the green card. You may decide you want to get the green card, and you know that you're not going to get a high rate of return on the project. It's going to be a fairly low return. Your money's going to sit there for a long time. So I would just say that keep a healthy amount of skepticism towards the EB-5 project, and rely obviously on immigration lawyers, not for business advice because we can't give that, but we can evaluate whether it looks sufficient for an EB-5.
So let's pretend I am a Mexican citizen interested in residing in the United States, but I am not in a position to start or invest in a business. What are my options?
So I'm going to run through these a little quickly because we've already been talking for a while. I don't want to keep us on for so long, but there are non-immigrant options that don't have to do with starting your own business or investing in the United States, but you need to find an employer who wants you to work for them, and you need to fit into a specific category. So the L1 or E2 can still work if you're coming as an employee, but either you need to have worked for a foreign company for at least a year, so that would be the L1, or you're coming to work for a Mexican company, so that would be for the E2. For the TN NAFTA visa, for example, this is only for Canadians and Mexicans. It's for specific professional categories. So this is engineers, architects, social workers, lawyers, lots of different sciences, some hospitality, management work, economists. So there's actually quite a range of different professional categories, but you still need to fit into one of them. So there's other details I have here on the slide, but I think we'll skip over them for now to try to leave time for questions at the end. The H-1B specialty occupation visa is for more professional categories than the TN, but it's still limited to occupation. So it's for professional level work, meaning it requires a bachelor degree. You must have a job offer from a US company, and there's a limited number available. So there's a lottery every March, or rather the beginning of April. It opens in March, they pick it in April. The filing fees are relatively high, so that sometimes will discourage some employers, but this is a much more broader category. So almost any job that requires a bachelor degree, so in the sciences, in tech, in finance, etc., will qualify for an H-1B. The O1 Extraordinary Ability Visa is for individuals with extraordinary ability in the arts, science, business, academics, or sports. This we use actually also for investors and entrepreneurs, I would say regularly, because you don't have the investment requirements, you don't have the ownership requirements that you do for the L1 or the E2, but you need to have a track record as an entrepreneur or an investor. You need to show that you have been recognized for what you've been doing. And there's certain specific criteria that you have to meet to show that you've been recognized. So it's things like publications about you, that you have been in a leading role with a company, that you have received a high salary, that you've received prizes, that you are a member of certain organizations. So it's quite flexible, but you still have to fit into these categories. The immigrant options for someone who's not an investor, wants to come as an employee. So we won't talk about the family options. We'll talk just about employment-based sponsorship. This is called the PERM process. It goes through the Department of Labor at first. The company needs to show that they could not find a US worker who is qualified and available to do the position that they want to hire you for. You need to advertise the job. You need to show that no one responded or no one qualified responded to the job. You need to show that you will meet the minimum salary requirements for that type of job as defined by the US government. And you need to show that you can pay those salary requirements. And so this is also a longer process, which is why I say this is an important distinction between non-immigrant and immigrant. This will not get you to the United States in 6 months. So if you want to relocate, if you have a job offer, and you're trying to get here, to the US sooner than later, this is going to take you, a good year and a half, probably closer to a year and a half. So that will be a long-term option rather than a short-term relocation. And critically, a company can't be owned by a relative without it raising red flags. So this sometimes becomes an option. You have a cousin, an uncle, a brother, whatever, who has a company in the United States. They have a position, they would love to hire you, but it's very hard in that case to show that they could not find anyone else and that they were not conflicted. And you have to state on the application whether the company is owned by a relative. And relative is pretty expansive. They don't just mean a sibling, a parent, a spouse. So there are situations where you can do this, but ideally not. And for some job categories, especially for Mexicans and certain other nationalities, but for some categories for Mexicans, there's a longer wait time because there's a backlog. So the more skilled the job is, the shorter the wait time. So if it's a job that you need a master's degree, it's a shorter wait time. If it's a job that requires a bachelor degree, there may be a bit of a wait time. If it doesn't require a bachelor degree, so this can be any job, a cook, a chauffeur, anything, does not require a bachelor degree, then there's going to be a longer backlog.
So,
Jesse.
The COVID-19 pandemic has affected the plans of transnational companies that were sending personnel to the United States. This is specifically the case for L1 visa applicants whose processes have been suspended due to the July 2020 presidential proclamation. What are the options for these companies and employees?
So this is a question that has come up, I know, for Jesse and DeForest for clients and companies.
Several of our clients, yes.
Yeah, and for clients I've been working for as well. So the proclamation, just to recap, stated that the consulates would not be issuing any L1 visas to new L1s. So what does that mean? That means that if you have an L1, even that's been approved by USCIS, by Citizenship Immigration Services in the US, you have the approval in hand, you go to the consulate. According to that proclamation, as far as we first learned about it, you would not be able to get a visa stamp in your passport to come to the US. It sounds absurd. You've been approved for the visa. Why should you not be able to get a visa stamp and come to the US? This was the proclamation. And it wasn't at all clear at that time even if this would apply also to renewals. So we know now it does not apply to renewals. So if you had an L1, you were in the United States, you need to travel, you can get a new visa at the consulate as long as you can get an appointment. They have since come out with a much longer list of exemptions to this restriction, and obviously we're now trying on case-by-case basis to fit people into these exemptions. So obviously public health, healthcare professionals, researchers for COVID, those are exempt. We always kind of knew, even from the beginning, they said these people are exempt. If you're coming for critical US foreign policy objectives to work for a US government agency, you're exempt. That's not going to apply to so many people. If you're resuming ongoing employment in the US, so that's renewals, you were working on an L1 in the US, you got your renewal, or maybe you were outside the United States, you got a renewal, you need a new visa, you're going to be able to go back and do it. These are the new exceptions. For senior level executives or managers who are meeting a critical infrastructure need. And then they give a long list of what is a critical infrastructure need. So again, you would always want to try to argue that you fit into one of these categories. Communications, IT, transportation, healthcare, etc. So you just need to argue you fit into this category. You need to then show as well that you are senior level executive or manager. So in theory, an L1 can be for a manager at any level as long as you're managing professionals, or you're managing at least 2 levels of hierarchy. So maybe you're not managing professionals, but you're managing other managers who then manage people working, on the assembly line or something like that. If you are 2 levels up, you're a manager. Now they're saying this exemption is only for senior level managers. Again, case-by-case basis. What is senior? If we slap the label on your title saying that you're now a senior manager, are you a senior manager? Have to argue this on a case-by-case basis. They want to see that you spent multiple years with the company overseas. So you cannot just have spent 1 year, which is the minimum that you need for the L1. And you need to show that you will fill a critical business need for the company, meaning a critical infrastructure need. So you are serving some sort of critical purpose for the company, and then again back to the critical infrastructure question. They're also saying that a new office L. So if you're coming to start a new company, even if you are CEO, you won't qualify unless, again, if you're CEO, obviously you're senior level, you need to prove that you're critical infrastructure, but the new office needs to employ either directly, indirectly, at least 5 US workers. They don't really explain what indirectly means, but the assumption is that this means like independent contractors. Maybe they're not on the payroll, but you're still employing them at some point in the chain of your business endeavors. So there are a lot of exemptions. There are some workers that are not going to qualify because this is really just for managers, executives, and obviously there may be cases where we have to really argue that you fit into this senior level role and that the critical infrastructure is part of what the business is doing. But it never hurts to argue this position. So I would say that if you even think that you qualify, but this is really going to hurt the people who are in specialized knowledge, or it is hurting the employees who are in specialized knowledge roles because they can't show that they're senior level executive or manager. So if you have extremely specialized technical skill that the company really needs, and maybe you're contributing very, very significantly to the company and to the operations in the United States, in the sense that you're making a big difference to the transportation network that this company is supporting in the United States, and you have very specialized skills that cannot easily be replaced by someone, you're not qualifying based on the senior level executive or manager. So you would then have to try to argue from a different direction that you will qualify for this, but that's going to be unfortunately a harder sell, at least till the end of the year. There's some alternatives to the L1 that we've been trying to move people into. So rather than try to argue this, rather than try to rely on the discretion of the consulate, let's go a different route. So the B1 in lieu of H1B is very specific. It's not used in a lot of circumstances, but it's a lot more effective than I think a lot of people realize, and a lot of people don't know about this as an option. So it's applying for a B1 directly at a consulate. It's a business visitor, but you're applying specifically for a B1 in lieu of, instead of an H1B visa, which is a specialty occupation visa. And normally you have to go through a lottery for an H1B. You need a US employer. In this case, there's no US employer. There's the foreign company. The employee is working for the US company. They have to come to the US for temporary assignments that are providing services in the US. So you can't use a B1, and we'll talk about this in a moment. It's way more than business visitors. You really are providing services to a US client, a US customer of the foreign company. The employee cannot be employed by them. So you're not transferring anyone. They're not actually working for that company, but they're providing services as part of perhaps a contract that the foreign company has with the US company. And you're still, the employee still remains employed by, compensated by the foreign company. And it's for short-term projects or short-term training. So let's say you're going to the US to train people on your software, or train people on your machinery, or on your product. Train the employees of the US company. That's great for a B1 in lieu of H1B. It also depends on the type of job, though. So this is people who are performing specialty occupation services. So that means it has to be a fairly high level of service. It needs at least a bachelor's degree. I would say that in my experience, they're not as picky about this at the consulates as they are when you're applying for an H1B, but you need to show that you either have a bachelor's degree in the area you're working in, or you have the equivalent amount of work experience. That's 12 years of work experience. So this will apply in a lot more circumstances than people realize. We use the B1 in lieu of H1B for a wide variety of different purposes, but it's not going to apply in every case. This is affected sometimes by COVID shutdowns. So because if you can't get a visa appointment, you can't get a B1 in lieu of H1B. But it has the advantage of being very quick. You just apply at the consulate. It's inexpensive. You don't have to pay high fees to USCIS, and there's no backlog or lottery or presidential proclamation that would restrict this. For the long term, we're trying to look at creative options because we don't know what will happen after the end of December when the presidential proclamation is due to expire. This may change in November. We may have more information about what immigration will look like for the next 4 years, but we're also having conversations with people about, okay, we can't get L1, it's out of the question. We don't want to wait for an L1 to see what will happen come December. Is there a TN as a possibility? Is there an E2 as a possibility? Is an O1 a possibility? So you need to look at the questions of who owns the company. Does it have Mexican nationality, for example? Does the employee have another nationality that would match the company that they want to come work for? Do they have another passport? And does the employee have any special distinctions or accomplishments? And again, this is case by case basis. You know, someone might have a lot of experience in their field and have worked in high level positions. They may have earned a lot of money for their services. So we may be able to try to see, okay, is an O1 a possibility? So again, really case by case basis, we're trying to be a little creative and flexible if the L1 seems like it's no longer a possibility.
So Rebecca, for what activities can transnational companies send personnel to the United States for short-term visits, either frequently or occasionally?
Sure. Sorry, I hope everyone is seeing the full presentation.
Well, we can see most of it. I think at some point it was kind of cropped, the presentation, okay. But right now it's okay.
Okay, sorry, I just noticed that there may be a problem. Okay, sorry, I'll switch back to this. So, for business visitors and short-term travel, the basics of a B1 business visitor, so you have a B1, B2 visa stamp, what can you come to do? It's a lot more limited than people think. You think you have a B1, B2, you can come in and you can, you know, be here sort of flexibly working. What's the harm? No one's going to know. That is not the case. If you are working for a US company or for a foreign company and you come on a B1, your activities are limited to what is defined in the law. So this means business meetings, negotiating contracts, conferences or trade shows, incubators, setting up a new enterprise. So if you're an investor and you want to do an E2 or an L1, you can come here for short periods and be here as a B1, setting up the company. The critical rule is, where are the services being provided? Are you providing substantive services in the United States? So all of these B1 limited activities are really ones where you're not engaging in services that are being provided to the US. So the classical example is, the classical case that is cited by Customs and Border Protection is of a tailor who comes to the US, takes orders for the suits that they're going to make, flies back to Hong Kong and makes the suits there. Now, this is a lot more fluid in a world where we're not talking about necessarily producing products. You know, a lot of work is done over the internet, or, you know, it doesn't really matter where you are, so you're not necessarily creating something. But if you are coming and let's say you're a consultant and you're coming and you're actually doing the consulting services in the United States, you know, you've come to the US, you find a client, they hire you to do some sort of consulting work, and you stay here and you do all the work and you present it to the client. That's not B1 activities anymore. That's substantive work. If you come, you meet with a client, you negotiate the contract, you go back to your home country, go back to Mexico, you produce the consulting work, or maybe you even did research in the US, but really you did like most of the actual work in a different country. That's fine as a B1. But as soon as you start doing services in the US, it starts to go over the line. You cannot receive compensation from a US employer or entity for service provided in the US, even if it never goes into a US bank account. It's still compensation for your services. So if your body is in the United States and the money goes to an account outside the United States, it is still, unfortunately, not B1 business visitor activities. So you cannot do it. The maximum stay is usually granted in 6-month increments, but every time you apply to enter as a business visitor, a customs agent can say, we're going to limit your entry to the amount of time we really think that you need, or the amount of time that you're until your return ticket.
Well, I'll ask one important question, and it's actually quite frequent that our clients ask us this. 6 months is the maximum stay with a B1 visa. But what would be a recommendable period for business trips in order to not raise red flags?
This is a hard question, and
Yes, it's a hard question.
Yeah, and it's on a case-by-case basis. The question of red flags, I would say that if you're really concerned about raising red flags, you need to think about maybe whether you already have raised them. If you feel like you're traveling too much and you're going to raise the red flags, then the likelihood is that a CBP officer may think that as well. Not guaranteed, but you never know. So if you're making frequent long-term visits, so you're staying months at a time, going back for short periods and coming back to the US for, again, a long period, they're going to be asking questions. There's a lot of people will give you a rule of thumb, like, you have to stay out for as long as you have been in the US. So if you come for 4 months, you have to stay out for 4 months. That's simply not true. It's really a case-by-case basis. It depends what you're doing. You may have a very good reason that you need to be here another time. Maybe you came for conferences and for business meetings, and you're coming back to do an incubator program for your startup. So that's fine. You can come in twice for 4 months periods if that's really what you're doing. But the more times you come in, the more you subject yourself to scrutiny. And even if your travel has been going under the radar for a long time, for years, let's say, coming in frequently, staying maybe for long periods, it doesn't mean that the next time there won't be an issue. So if you already get, instead of using a rule of thumb, I would say that if you already got the feeling that you are maybe staying for too long, already maybe talk to an immigration lawyer about either whether you need a visa, maybe what you're doing really just doesn't qualify for B1 anymore. You should be proactive and try to get another visa, or about documenting the reason that you're coming and having that really prepared. So when you come in, if you do get pulled aside, if you do get subject to that more scrutiny, then you're already ready to present a really good argument for why this is still B1 permissible activities. I also want to mention, I'm not going to go through all these categories, but under NAFTA, there are very specific permissible activities that don't otherwise apply to B1 visitors from other countries. So this is not just the TN visa, but this is also things like after service. So if you have a client in the US, if you have a customer in the US and you need to go train them on it, you need to service it, you need to, you need to engage with them in some way and connected to your product or connected to your services in some way, then you may fall under this exemption. And that can be like fairly flexible because it applies to software, it applies to all different types, as well as machinery and goods and things like that. So this can be a lot more flexible than what you may normally think, and certainly more flexible than for normal B1. Oh, and that brings us to the end of the presentation, unless you have questions for me.
I think there are no more questions, and I have asked the most relevant ones, so that would be it for this workshop. Of course, I would like to thank you for giving us this excellent presentation, and if anyone had another question or need a more specialized legal consultancy, please feel free to contact us via email, and well, that should be it for today. Thank you very much, Rebecca.
I mean, we can wait for a couple of minutes to see if any attendees have any questions they want to jump in with, but otherwise, I'm happy to answer anything about what we presented or other immigration topics.
Yeah, well, until we wait, if there's any more questions, take Rebecca. Hi again. It was really interesting, and please, all the assistants, do not hesitate to ask any questions that you may have. And thank you very much again for being part of this workshop. I think it was really complete. So thank you, Rebecca. Thank you, Jessica, for being part of this The Forest Legal Talk. And again, do not hesitate to ask any questions now or later. You can send an email to each one of us or to Rebecca directly to the Forest Legal Talk email, and we'll happy reply with the information you need. Thank you very much and good night.